of World Arbitration Update. Sorry. My name is Maria Camila de Brigard. I'm a senior associate at Strategy, a boutique law firm with presence in Washington, D.C. and Bogota. And I am also part of the executive team of World Arbitration Update. Before we start, please allow me to introduce the speakers that will say a few words before our keynote speech. So first, let me welcome Ms. Jiang Lili, Secretary General of the Beijing Arbitration Commission. Ms. Jiang.
Distinguished guests, esteemed colleagues, ladies and gentlemen, good morning. And a very warm welcome to all of you. It's a great honor that we may host the WAU China Insight. For the first time, WAU comes to China. We are thrilled to have engaged 49 guest speakers, over 120 attendees presented here today, and nearly 300 audience participating global online. Is the date from last night. Coming from 16 jurisdictions on behalf of BAC, I would like to express my sincere gratitude to every one of you for joining us, to extend a special welcome and appreciation to Mr. Jose Rivas, Mr. Ian Laird, Mr. Robert Sargent, and the WAU global teams for their efforts and passion for organizing the conference in the past 3 years. I would also like to extend a special thank you to the conference sponsors, Huamao Guigu Law Firm, Tiger Partners, Global Law Lawyers, Yuanhe and 12 Tables, Dacheng Deheng Law Office, Dahui Law Lawyers, Double Care, and Global Law Office. Our supporting organizations, the Belt and Road International Lawyers Associate, Polander, LexPR China, and our technical support, Fly Tech, for their generous support to WAU China. BAC Beijing International Arbitration Center takes great pride in its role as a nexus of international arbitration, facilitating the arbitration community with multiform communications and dedicating to provide users with high-quality dispute resolution service. As the only capital arbitration institution in China, BAC has been recognized as the most vibrant institution with a spirit of reform and innovation. BAC is noted not only for its high standard arbitration service in line with international rules and practice, its efficient management and reasonable compensation paying arbitrators, but also for its remarkable contribution and influence in international exchanges. In 2023, BAC has successfully been elected as the rotating president of APROG, Asia Pacific Region Arbitration Group. A few reputable media such as The Economist, the Global Arbitration Review, have consistently recognized BAC as the most influential arbitration institution in Asia Pacific. Along with China's developing into the world's largest trading state and the fastest growing economy, BAC recognized that the arbitration market in China has witnessed impressive growth in recent years. In 2023, over 600,000 cases have been registered in China, with the total sum of disputes amounting to nearly 12,000 billion RMB. The cases in Beijing is about 19,000, carrying over 280 billion RMB dispute amounts. These figures highlight the large potential of an emerging arbitration market in China, and outlines a surpassing demand requiring for quality disputes resolution service. Beijing stands as the representative of that emerging potential and market demand. Beijing has been ranked sixth in the survey of the most popular destination for international arbitration. Beijing enjoys unique advantages in terms of dispute resolution resources and is provided with more favorable opening up policies and promotive legislative support. A public welfare project of the Beijing International Commercial Arbitration Hub has been initiated to promote a more friendly and favorable business environment. One of the primary support is to facilitate more international arbitration institutions and professionals to operate their business in Beijing. A brief introduction to the construction of the International Arbitration Hub and the physical platform Beijing IDRC, International Dispute Resolution Center, is provided in a leaflet attached the conference materials to you. I truly and firmly believe that Beijing's reputation as an emerging preferred international arbitration destination is well deserved. This is the first time WAU is held in China, and this marks a promising start. BAC would like to seize this opportunity to bridge communication between China and the global arbitration community. We invite all dear friends and colleagues to come to China and enjoy this uplifting journey. Apart from the conference, I hope you will have a chance to experience the life in Beijing. I'm sure you will be convinced that Beijing has maintained a very open, friendly, and diversified international society. With the conference a great success, wish you a very fruitful, constructive, and pleasant stay in Beijing. Thank you.
Thank you, Ms. Yang. Now please welcome Jose Antonio Rivas and Ian Laird, co-founders of World Arbitration Update.
I'll be very brief. I just wanted to welcome everyone and all of our viewers streaming online to the 4th annual World Arbitration Update. We founded this conference in the midst of COVID, and it was a chance to bring together arbitration practitioners from all over the world while we were all locked up and a little, under the weather, so to speak, because of circumstances. But that opportunity to bring people together to highlight the diversity of our practice turned out to be a very rewarding experience, and we've now continued on for the 4th year. We have sessions now this year in Singapore, in India, Warsaw, Bogota, Washington. It's really a remarkable reflection of the international scope of international arbitration, and it is an extreme honor to be here today at the BIAC Center. As Madame Zhang mentioned, the BAC has turned into a powerhouse in international arbitration, and I think it's only fitting that we're here showcasing to the world the strengths and all of the excellent work that is being done here at the center. I'll just ask my colleague, Jose Antonio Rivas, to finish off a few opening comments, and then we'll get started on the conference.
Thank you, Ian, and welcome to World Arbitration Update. It is a true honor to be here with experts in international arbitration, with Madame Yao, with representatives from BRILA, with Ms. Jiang, Mr. Chen, and those that have been able to make this possible. I would like to emphasize 2 key principles that have motivated us to create the World Arbitration Update 4 years ago. One is to update the world, the practitioners, arbitrators, students, professionals, as well as academics, on issues of one, international arbitration, international commercial arbitration, then international investment arbitration, and public international law. Those three, in many respects, form a basis of the international rule of law in international economic law. And we emphasize the notion of updating the public through panels of experts. And we started that and saw that this was a way to communicate with the rest of the world what are the latest issues on international investment, commercial arbitration, as well as public international law. Because today it is very difficult to get an update by reading all the decisions that come from various arbitration centers, so there must be means to facilitate that. So one is to update. The second one is the decentralization of international arbitration. And by that we mean that international arbitration traditionally has been seen as something happening in Paris or New York or London or even Washington, D.C., and it would be a mistake to see international arbitration as just in those places, because international arbitration, as we know, is happening in a vibrant way in Beijing. It's happening in Latin America, it's happening in Eastern Europe, it's happening in so many places. In addition to the traditional centers, there are incredible practitioners, arbitrators, damages experts who are here, based here, and who are doing all these proceedings as counsel, as arbitrators, and contributing to the formation of international arbitration. So that's why we're here. And a year ago, I happened to be invited to Guangzhou for a conference. That's where I met in person Madame Yao. And in addition to that, I saw how vibrant the community is, and one objective was to create international arbitration forums through with the World Arbitration Update in China, and that's what we're doing today. So it's an honor to be here. It's an honor to be among experts, as well as eager to learn from you and make this part of the broader World Arbitration Update community. Thank you very much.
Thank you both, Jose Antonio and Ian. Now we will hear a few words from Mr. Yang Yuan Qing, partner at ZHAO and Gigu Law Firm, who is our diamond sponsor for this event.
Distinguished guests, ladies and gentlemen, first I would say it's ZHAO and Guigu. So you can see, we need to share our knowledge and even pronunciation to in this vibrant world. Good morning, everyone. On behalf of ZHAO and Guigu, which has the honor to sponsor this conference, I would like firstly to extend my most sincere thanks and warm congratulations to the Beijing Arbitration Commission, BAC, and the World Arbitration Update, LLC, for co-hosting the World Arbitration Update Conference 2024, China. I would like to thank the host for creating such an excellent platform for experts and practitioners in the field of global arbitration, including but not limited to arbitrators, staff from sister arbitration institutions, lawyers, and so on, to get together and discuss the cutting-edge topics of international commercial arbitration and investment arbitration. And I would like to thank two co-founders, Mr. Jose Antonio Rivas and Ian A. Laird, as well as Mr. Sargin, who I met yesterday at the reception. I noticed that many of the guests and the audience of this Congress have just attended the International Council for Commercial Arbitration Congress 2024 in Hong Kong last week. This event conference organized by BAC and WAU with the same in-depth and broader topics will surely provide us with a deeper understanding of the new developments of China's arbitration, as well as the new trends and the challenge of the international arbitration. The theme and the content of this conference once again highlights the dynamic development of the field of arbitration. In addition of the oft-talked about Belt and Road Initiative, public interest issues in the recognition and enforcement of international arbitral awards, quality and efficiency of case management, to which all the arbitration practitioners pay a lot of attention to, and third-party funding. The conference also tackled the challenges of investment arbitration faced by Chinese enterprises and the Chinese government in the new era, as well as the ways in which arbitration can support environmental protection, which is a national policy of China and a concern of the whole mankind. We would like to express our appreciation to the hosts for their excellent arrangements. We highly commend and thank the hosts for the elaborate arrangements, and the pragmatic and in-depth topic demonstrated a high sense of responsibility for the cause of arbitration, which also reflects BEC's consistent sense of social responsibility. This conference adopts AI voice recognition, and I'm paying attention to whether it's accurate or not, and to display Chinese and English subtitles in real time. And this attempt of BEC demonstrates the sharpness of BEC in data and technology. I would also like to express my deep gratitude to all the presenters and moderators who participate in the conference, as well as the online and offline audience. There is a saying in arbitration that an arbitration is only as good as the arbitrator. And I would also like to say that a conference is only as good as the moderators and the presenters. Your wisdom and insights will add to the splendor of this conference and will advance to the cause of arbitration. And again, thank you all the presenters and the moderators. Against the backdrop of a widespread interest from the global arbitration community, China arbitration system continues to improve, provide a reliable and efficient dispute resolution mechanism. WAU 2024 China will be able to contribute new wisdom and strength to the development of arbitration and international arbitration. BEC will surely travel steadily and far on the road of building an international arbitration brand and help the construction of foreign-related rules of law in China and the arbitration center. As a law firm that has been working with arbitration for 30 years, Huamao and Guigu will continue to contribute to China's foreign-related rule of law and arbitration endeavors. Last but not least, on behalf of Huamao and Guigu, I would like to wish the conference a complete success and brings a lot of updates to our knowledge and experience. Thank you.
Thank you. Now we're gonna welcome our keynote speaker. This is Professor Zhao Hong, sorry. She's a professor of law at Peking University and a former member and chairperson of the appellate body of the World Trade Organization. We're very glad to have her. So please.
Good morning, everyone. Distinguished legal community of arbitrators at both home and abroad. Because I don't know how many arbitrators, I know many familiar faces, maybe take too much time for me to mention all their names. I think we form a legal community of arbitrators, at least this morning. So I'd like to thank the Beijing Arbitration Commission, as well as the World Arbitration Update to co-sponsor this important event in Beijing. Now, as to the second sponsor, I recognize it only this morning when I come into the room, because it is the Beijing Arbitration Commission who contacted me and invited me, and I thought it is an event by them. I do not, and I thought there's a moot court followed that. So but I'm very glad to see the familiar faces, the friends, Hugo, Ian, and Robert, and I'm really glad you've been here in Beijing. But as it is quite event, and I should acknowledge I didn't prepare it really so thoroughly. As I teach the whole morning, I prepared the slide only last night. So there might be problem inside it, so please forgive me for the mistakes, or in the, there are issues that should be, I posed questions, I think, this morning, and it is my reflection over a short period of time, focusing on the function of arbitration in the history and in the current days, at home and in international dispute settlement. So I will propose the ideas that is in my mind, and I hope that will help exert more energies and wisdoms in the whole legal community worldwide to think about these matters, so that we can build a better world with the international rule of law, not only domestic rule of law, but international rule of law. So the ideas is to talk about arbitration in history of East and West, and the contribution of arbitration to development of international law. I may not have time to talk the reform of arbitration law of China, as I have 25 minutes. And the reason to start with history is actually because I think we are at the crossroad of where to go for our future development of international law. We suffer many setbacks and difficulties, in particular in certain areas of international adjudication at some international organizations, including that of the World Trade Organization, which is an organization I served for 4 years before I stepped down to come back to the University of China, the Peking University, the alma mater of me in Beijing. The reason is because I think that the reason is not only because historical schools are important idea contributor to the world, to legal doctrine. The historical school represented by German historicist Professor Savigny, who proposed the law is but a reflection of the spirit of a nation. So at the crossroad, what for us to carry on? The heritage in history is something we should reflect. That's why I start with the history, to have a reflection of history. But let me start with some certain definition, what the professor usually do for the lecture. Now, for me, the key messages I hope you can take away is arbitration is a supplementary means of adjudication in not only domestic system, but in the world adjudication. That is my personal view. I will give the judicial decision to settle a dispute through judicial services by a state is a key function, the key and integral function of a state ever since the state, the so-called state, which is a technology, which is a key terminology within international law, ever since state come into inception. And arbitration from history, that we can date it back early to history, is a supplemental means to support, to help the settlement of dispute, to, apart from the judicial services rendered by the state. So arbitration is there forever, from very early days, both in the East and West. Let me start by So arbitration usually we understand to submit a dispute to a decision to person or persons as a third party other than the court of competent jurisdiction of the court, other than the court of a competent jurisdiction. So it's a supplementary to judicial decision. And adjudication has been understood by some. I quote from this definition from the history of international law. Adjudication has been usually referred to the judgment or decision of a court. But to me, this definition may be a bit narrowed. To me, adjudication can encompass, in a certain sense, not only the judgment of a court, but also a judgment by, how do you say, a tribunal, consists of arbitrators. So that is my personal understanding. So I pose the question, how do we define the terminologies, the key terminologies of arbitration and adjudication and judicial or quasi-judicial decision? I will come to these terms, which are the key of dispute settlement internationally. Now, the distinction of arbitration and adjudication, if we understand adjudication in the way that has been defined as a judgment of decision for court, may not be, maybe less than it is perceived, I should say. You know, I quote this from Brownley's Principle of Public International Law that was published, by Oxford University Press. The distinction may not be that as people perceived. We are in the domain of arbitration, and the people in the world of the court, we think there's a distinction, a line of distinction should be drawn. But according to him, I found, when I'm reading this, I found, yes, somehow, there may not be a sharp line between arbitration and the judicial settlement. And the latter is applicable to any international tribunal setting disputes involving state or other parties in accordance with international law. And I think the understanding is that for the composition of the tribunal of arbitrators, but at least to me, it is the consent, it is all at least based on the consent of state. If we think about the consent, that I think the distinction would be even more difficult to draw that line. So I hope I make myself clear. As international adjudication, we refer to mostly that adjudication is based on the consent of the state. And when we talk about judicial decision, judicial process, we are referring to a process that is more or less more compulsory or with more binding effect. But well, if you look at, if you read into the classic textbook of public international law, you may find authors may not think the line is so strict or straightforward. Well, I think I pose this, I do not pose this issue with a conclusion. I think I pose this as a question that arbitrators and adjudicators can think about. Where to draw the line, what are the commonality and what are the distinctions of the two ways, the two methods of settling of dispute. So a question mark, I hope that will be kept in your mind. And the way to look at into history will be very broad, very briefly, as in history of China, in Zhou and Qin and Han dynasty, you found, we say, Tiaoren and Sefu, because they are the precursor of mediator and arbitrator. I won't explain in detail how, in history, how they work. They mediate. There are mediators in ancient time of China, and there are arbitrators, the officials, the local officials, in particular in the county. They are part of the official team of the dynasty, but they are in charge of everything. They are in charge of administrative matters and the settling of dispute. And their work is the arbitration, and to me, it's a sort of arbitration. Arbitration and mediation will be the function of will be side by side. You know, in China, the mediation is a character of the judicial process of China since the ancient times. So I think the unitary system of administration and judicate matters, and the unitary system of judicial system of civil commercial matters, civil commercial and even criminal matters are the character, the unitary. It's one person in charge of everything and sitting in the court of, you know, maybe the government of, you know, the local government. They are everything. Anyone who have a lawsuit go to, you know, knock the door even at midnight, and the head of the county will rise up and listen to the suit. So they basically, so these are the, and my student helped me doing something. I think it's better than what I do. So the core concept is emphasizing harmony over litigation, the social foundation, the cultural tradition, practical approaches in dealing with the settlement of dispute in ancient times of China. And basically, the Chinese prefer the suspension of litigation, or litigation-free, or no litigation. That is a culture. That's why mediation and conciliation and arbitration could be a tradition of our culture. So I think so I incorporated his, there are a few, and later on, of course, I didn't pay, and the guild is the commercial association of China, and they have its own adjudication bodies, enforcement mechanism, and penalties even. So they helped. So it is another branch helping how dispute could be settled in ancient time of China. And the clan, I think the other is the clan, the family, within the clan, the big family. It is the head of the family, the authority of the family, who will decide the conflict dispute among the family members. That's also a great branch so it is the official branch of settling dispute, the family branch, and the guild. So the three pillars in settling dispute in ancient time of China, roughly speaking. And let's take a quick look at what is the tradition of the West, the arbitration in the West, the three phases in history. Now, to me, this is all quite natural. While in medieval times, no, I also quote this. You know, I quote this from the History of International Law, published by the Cambridge University. The three phases, division of development arbitration in the West. There's a chapter. So the medieval times, as this, it is all under the common Roman Catholic faith and authority of Catholic Church. The political subdivision actually did not prevent arbitration to be popular at the time. And the Pope, the church people, usually will be the people who act as arbitrator to help settle dispute. This could be dated back even to ancient Greek and Roman times. So, and the prominent feature of the medieval times are the law of arms and the price law. This is also according to the book I quoted, The Persistent Ideal of European Arbitrator. While the second phase is the early modern period, the age of diplomacy, the rise of the diplomacy, the professional law team. I understand that the law professor and the diplomatic circle helped a lot in settling dispute for the disputes among the nation of the Europe, that marked a decline of arbitration in a certain sense. That it is quite mysterious to me why there's a decline. But there's a debate whether there's streamlining of the development of arbitration in the West. But the factual situation is that somehow arbitration are less popular in the early modern period after the Westphalia, the treaty of Westphalia. Is it because of the sovereign of state has been recognized? It is more peaceful among them, that there are less dispute among the European states, or it is because of other things, the rise of the international scholars. I think this is a question mark that if anyone have interest can continue to dig further into the history why there's a decline in the early modern period. So the Grotius, the Mea Liberum, the Liberty of the Sea, was published in those days. There are, other key international professors, quite famous, Victoria and others. Victoria even earlier and then ZHAO of the Swiss. They published many works, promulgating the idea of international law. In the 17th century, so the recession, we said there's a recession of international arbitration in practice, and people are asking why, and I'm thinking about why. And then the first arbitration treaty, which is quite famous between British and American, is the ZHAO Treaty. They established a mixed committee in settling the dispute for the citizens of the US or the British for the claims they have with each other in wartime, and they settled many disputes. But at that time, they select only arbitrators of the two nationals of the two states, British and the American. They don't select the third arbitrators from third country. So it is quite interesting, and they set quite a number of precedent, very interesting time in settling dispute. And the 19th and 20th century marked another rise of arbitration, and even the creation of institutional arbitration, the permanent court of arbitration, for example. I think many of the history you've been aware, and I won't go into details of it. So the commonality, according to me, and the distinctions, I think both in the East and West, we see that dated back, arbitration could be dated back to early history, or something similar with arbitration could be dated back very early back to the history. And it has always been acting as an alternative to the resolution by courts in states in the West and the East, in the dynasties of China in the East. And it is a supplementary means to adjudication, both at home, both in domestic and international affairs. And the ultimate arbiter in the old times, the Pope could be one. The Pope used to I'm sorry, I need to be very quick. I was reminded I have 5 minutes. So the distinctions, the West, the cultural focus on the rights of individuals, party autonomy and freedom of choice, and the procedure, the procedure matters. There's a much emphasis on the process. And China, I think there's emphasis on the outcome. The outcome must be justice. The law itself has connotation of that element of justice. In the law itself, I didn't mention the character of law in China. And the West is a vast team of legal profession. The lawyers play important role in the development of arbitration, and they put a lot of tremendous pressures even on the someone said pressure, for the evolution of dispute resolution in the West. Well, so what arbitration, what contribution arbitration did to the development of international law. That is the second key question I pose to today's meeting. Substantively and procedurally, I think it did quite a lot, not only in the area of a private commercial area of international law, but to the state, the sovereign state relationship, the public affairs, public international law. So the impact, as Hugo mentioned in the beginning, the idea of having this seminar is also to promote the development of public international law. So at least to me, I think it's a very big question. I'm still reflect over this matter. It could be regarded as evidence of customary rule of the state practice of international law, at least. The way the state propose their views, ideas, and the positions before a tribunal, international tribunal of arbitrators, for example. And the acceptance of the jurisdiction of arbitral tribunal and the implement the decision of that tribunal has a huge impact and implication for the sovereign, for the concept of sovereignty in public international law. I think that manifests the, it manifests the change from absolute sovereign to limited sovereign, at least relative sovereign, at least to me. And it's also representing an evolution of customary rules of concept, doctrine, principles of international law, not only limited in sovereignty, in particular in the way how the tribunal interpret the treaties that the state freely entered into. So I think there's a lot. I won't mention, at least Alabama case. It is interesting that the British government argued that the United States is also, I think, the time after the wartime of after the independence of American from the British, the settlement of dispute. There are quite a number of cases. Alabama would be one of those cases that the United States believe that British hold international obligation to be neutral, to be neutrality, but Alabama was a fleet, fast ship built. So they said the U.S. you can't help build or repair that ship, but the confederations understand take that ship, and that ship destroyed many of the ships, caused quite a casualty to the north. And later on, there's arbitration on that matter. And the British argues that it is the government of the British do not have the right to control that ship diplomatically, but the court, the tribunal believe that it is the state of the British who are liable, who are accountable under international law. It's not the government. The division among themselves doesn't matter that much. So I think at least this is a matter that we can, so this is part of the development of the idea of how state, the liability of the state. I was told that's 1 minute, but so you will see that even international adjudication or international quasi-judicial settlement of dispute or international judicial settlement of dispute. I think there's a consent to me, there's a pathway, progressive pathway from consent to quasi-judicial settlement of dispute internationally. The consent would be more or less referred to arbitration. So is it progress is a question I'm asking, and I've been written an article in that regard. But look at the World Trade Organization, some of the most prominent international institutions. We have panel stage, appellate body, the appeal stage, 2 tiers. And now we have multi-party international, the settlement of the appeal of arbitrations. So the multi-party arbitration, someone will say panel will be more or less like arbitration. The 2 parties choose the panelist, and for the chair, for the For the chair, they may invite the DG to appoint the chair of the panel. So whether it is be more characterized as arbitration or it is judicial or quasi-judicial, but it is for debate. I just pose these issues and you may reflect what are the genuine nature of panel appellate body and the multi-party interim system of settlement dispute at World Trade Organization. As that one, the multi-party, that was based on Article 25 of the SU, which is arbitration provision. And the appeal will be conducted by the members to MPIA, which is a plurilateral agreement for settlement of dispute. So they will use arbitration to settle their dispute after the panel deliver its report. They suspend the panel according to Article 12 of the SU. And the ICSID, by nature, it is arbitration. The convention of ICSID, the Washington Convention, is the settling dispute of investor state through arbitration, conciliation, and other means. But that arbitration decision do not need to be recognized as a final award. It is final and will be implemented by members. Someone say automatically, whatever. It is unlike those judicial arbitrations and the New York Convention, you need to be recognized firstly by the local court. It is award. It is arbitral award and the New York Convention so that it can be enforced. So there are nuances in all these process, all these typical international adjudication processes. And so arbitration, adjudication, judicial or quasi-judicial, what are the natures of all these international settlement, the method of international settlement of dispute? I think this there are many rooms for students and a professor to write articles, to deliver thesis, and for lawyers to, to render our reflections. In particular, I think I need to stop, but there are other things I can, I want to say something as international adjudicator at the World Trade Organization, the appellate stage. I'd like to share with you some of my concerns. Somehow I feel what are the challenges common to all international adjudications. Arbitration, judicial, quasi-judicial. I mean, it is all based on the consent of the state. How long does the consent of the state last? The state may change their mind. In particular, it is an institutional arrangement. How to strike the balance between the independent impartiality of judiciary body or adjudicatory body and the influence of outside. How to deal with the situation of constructive ambiguities in the rules of the treaty, in treaty languages, and the requirement of parties to resolve their dispute over these ambiguity matters, ambiguity treaty obligations. How to manage the influence of different major legal systems, the civil law, common law, etc. And we understand all the international tribunal, either arbitration, judicial, quasi-judiciary. It is mostly the lawyers from the Anglo-Saxon world. Someone said 70, 80%, even more. So where are the rest of the world? Now I conclude by, I would like to quote this, law has been regarded as a part of the distinctive manner of the imagining of the real. And the international lawyers always believe there's a legal imagination of the world, by them. So how do we imagine what we do? And I think it should be the whole legal community, East and West, together, and knowing where we're from and taking the culture, tradition, that is suitable, that is grown from this land, this territory. So I think there's a vast mission for every lawyers, whether you're serving the domestic affairs, international affairs. There's many things for us to imagine, maybe. So while doing the daily work, do not forget about that legal imagination. Thank you.